Have you ever wondered what actually happens when two official laws say completely opposite things? I mean, when one rule says, you must do this, and another rule screams, no way, you absolutely cannot do this. Who actually wins? Well, welcome to our explainer. Today, we're talking about a concept that acts as a literal superpower in the legal world. We're going to decode the non-obstante clause. It's essentially a statutory bulldozer that lawmakers use to establish absolute dominance when legal texts collide. It's a fascinating mechanism, so let's jump right in. Okay, if you've ever tried to read a dense legal contract or a piece of legislation, you've probably tripped over this rather intimidating phrase, notwithstanding anything contained. It sounds super archaic, doesn't it? But seriously, don't let the old school vocabulary fool you. This phrase is a massive foundational tool. Lawmakers use it as a trump card to just bulldoze right through conflicting rules. It basically asserts that the sentence immediately following it is the supreme law of the land, regardless of whatever else has been written before. To get a bit technical for just a second, a non-obstante clause is exactly that. It's simply a phrase slapped onto the beginning of a section of law to give that enacting part an overriding effect in cases of irreconcilable conflict. So the absolute crucial takeaway here is that it strips other provisions of their capacity to abstract. It's basically telling every other conflicting law in the vicinity, hey, step aside so that this primary law can operate fully and naturally. To really unpack how this works, we've got a quick 5-part agenda. First, we'll look at the fundamental power of notwithstanding. Second, masters, servants, and parallels. Third, the two-step clarity rule. Fourth, why lexical boundaries matter. And finally, resolving legal clashes. Section 1. The power of notwithstanding. Let's explore how dominance is fundamentally established right there in the text. When you dive into the original study notes on this, the core purpose is crystal clear. The whole point is to give the enacting part overriding effect if it irreconcilably clashes with another specified section, or even entire sets of laws. The clause ensures that the provisions it protects just don't have the capacity to obstruct the full natural operation of the enacting section. Think of it as both a shield and a sword for the law it's attached to. Moving on to Section 2, Masters, Servants, and Parallels. You see, notwithstanding doesn't operate in a vacuum. There's a strict hierarchy of these legal phrases. It helps to think of legal drafting as a strict power structure. On one side, you have notwithstanding, which we can call the master. It always wins over its target provision. It dictates the terms, period. But on the exact opposite end of the spectrum, you have the phrase subject to. Now, this is the servant. Whenever a law says it is subject to another law, it's raising a white flag, signaling that it must yield its place to a master provision if a conflict arises. The power dynamics are baked right into those introductory words. If we map out the full landscape of these power phrases, it gets really interesting. We've got our master, notwithstanding, winning the battles. We have our servant, subject to, yielding to higher authority. But we also have two others in the mix. Without prejudice acts as a parallel, meaning actions taken under its clause must stay consistent with and preserve another law. They run side by side. And finally, save as otherwise acts as a general baseline that yields only to a very narrow specific exception. So just by spotting which of these 4 phrases a lawmaker chose, you immediately know the intended pecking order of that statute. All right, Section 3, the two-step clarity rule. Lawmakers have this massive power, but courts definitely don't let them just swing it around wildly. This brings us to a really famous precedent set by Justice Patanjali Sastry in the Ashwini Kumar Ghose case. The court established a strict two-step clarity rule. Step 1, you must first give the enacting section a fair construction in its natural and grammatical sense. Basically, you have to figure out what the law actually means on its own 2 feet. Then, Step 2, only if an obstacle or inconsistency exists with another law do you actually trigger the non-obstante clause to clear that obstacle. It's often treated as a tool of abundant caution. You absolutely cannot use the overriding clause to magically expand the meaning of a poorly written law. The enacting words themselves must be perfectly clear first. Section 4. Lexical boundaries matter. Now that we know the rules of engagement, let's look at how exact wording defines a clause's blast radius. I cannot stress enough how much words matter here. A non-obstante clause isn't just some infinite bomb. It's a highly targeted strike. For example, if the text says, notwithstanding anything contained in this act, the clause only overrides other sections within that exact same piece of legislation. It's strictly internal. If it says contained in any other law, it can override external laws, but, and this is wild, not other sections of its own act. And if it says contained in any enactment, it only overrides officially enacted legislative laws. That means it cannot touch common law rules, ancient customs, or constitutional charters. The blast radius is entirely defined by the vocabulary. Let's look at a real-world battle over these exact lexical boundaries, the Sharda Devi versus State of Bihar case. The entire core of this dispute rested on Section 54 of the Land Acquisition Act. That section used the phrase, notwithstanding anything to the contrary in any enactment for the time being in force. This whole massive case hinged on exactly what that single word, enactment, legally touched. And the stakes of interpreting this one single word were incredibly high. An appeal from a trial court went up to a single-bench high court, where it was dismissed. The state was pretty aggrieved by this, so they filed a letters patent appeal before a division bench of the high court, which actually allowed it. Sharda Devi then took the matter all the way to the Supreme Court, questioning if that appeal was even legally maintainable against the overriding wording of Section 54. So how did the Supreme Court rule? Well, they held on to a very strict interpretation of the non-obstante clause, specifically because it targeted the word enactment. The Supreme Court declared that a letters patent is a constitutional charter establishing high court powers. It is not a legislative enactment. Therefore, the non-obstante clause simply could not override the letters patent. It just goes to show you that even a statutory superpower has strict kryptonite depending on the exact vocabulary the drafters chose to use. And finally, Section 5, resolving legal clashes. We know how the superpower works, and we know its limits. But what on earth happens when two superpowers collide head-on? Imagine this scenario. It's known in the legal world as the double NWS clash. You have Statute A governing bank debts, and it explicitly states, notwithstanding anything contained in any other law, bank debts shall be recovered first. Okay, clear enough. But right across the street, you have Statute B governing SIC companies, which loudly states, notwithstanding anything contained in any other law, SIC companies are protected against recovery. You see the problem? Both statutes are simultaneously claiming absolute overriding power over the other. It is quite literally an unstoppable force meeting an immovable object. To referee this kind of heavyweight fight, courts rely on a judicial framework established decades ago in the 1977 Sarwan Singh case. When faced with two non-obstante clauses just staring each other down, the system needed a bulletproof way to crown a winner. So the Supreme Court established three crucial tests to resolve this. First is the test of underlying purpose. What is the actual core policy or social objective of each law? Second is the test of chronology. Generally speaking, a later enactment in point of time normally prevails over an earlier one because it represents the most recent will of the legislature. It's essentially the newest update to the rules. And third, the special versus general law test. A special law will prevail over general law even if the general statute was enacted later and contains its own non-obstante clause. Let's see these tests applied in a massive real-world clash. The KSL and Industries case back in 2015. On one side of the ring, you had the Sick Industrial Companies Act, or SICA, enacted in 1985. On the other side, you had the Recovery of Debts Due to Banks Act, or RDDB, enacted later in 1993. Both had non-obstante clauses. Now, the bank debt law was newer, which, according to the chronology test we just talked about, should give it an edge, right? But let's look a little closer at the fine print. When you compare the actual text, SICA, the older law, had a standard clause overriding any inconsistencies. But notice the newer law, RDDB. It included a very specific caveat. It stated that the provisions of RDDB shall be in addition to and not in derogation of SICA. And because of this robust framework, SICA, the older law, actually prevailed over RDDB, the newer law. The Supreme Court recognized that SICA was a highly specialized law designed with a specific social objective to protect SIC companies and keep workers employed. The bank debt law, while newer, was way more general in its approach to debt recovery. So the specialized nature of SICA, combined with that specific textual carve-out in the newer law, meant the older master retained its crown. It's honestly such a fascinating look into the architecture of our legal system. We like to think of laws as these rigid, absolute rules, right? But as we've seen today through the mechanics of non-obstante clauses, laws are constantly negotiating for power. They're bound by strict lexical boundaries and subject to intense judicial refereeing. It leaves us with a really provocative thought. If these statutory superpowers can clash and be overridden based on technicalities and timelines, are any laws truly absolute? Or is every master provision merely waiting for a newer, more specific master to come along and take the throne? Something to think about. Thanks for exploring this explainer with me today, and keep questioning the rules.